Today is April 25th, 2011. This is Children and Justice. We are in Learning Module 7. We began Learning Module 7 last week, and we're going to finish it up rather quickly because on the schedule we're supposed to be beginning Learning Module 8, which is a 2-week learning module, and that kicks off with expert witnesses. But Learning Module 7 was about confidentiality, and as I said to you last week, people often say, oh, these records are confidential, or I can't share that information with you because it's confidential. Well, talk is cheap. Confidentiality has to arise from somewhere or something. And we learned that there are 3 sources of confidentiality last week. Can someone just give me one source of confidentiality? Give me a source of confidentiality. Where does it arise from, partner? Well, that's an example of a privilege. So a privilege is one kind of confidentiality. Can someone tell me where we find privileges? It's a lawyer book. It's a lawyer's book where we find privileges. They're kind of statute books. Who said that? Begins with an E. Evidence. Who said that? Evidence. It's in the rules of evidence. The book of evidence rules. Okay? Well, I said that informally. It's in the rules of evidence. In the New Jersey rules of evidence, you find privileges. And that's important to remember because that means that privileges only apply in legal proceedings. It's a rule of evidence. There could be a privilege for news persons, which there is, I told you about it last week, or there could be a privilege for bicycle riders. Well, just because there's a bicycle rider's privilege in the rules of evidence doesn't mean that the documents that are generated by bicycle riders are confidential. Because privileges only have to do with legal proceedings. So that is one source of confidentiality in our state. Within the rules of evidence, you have privileges. And as the name implies, these privileges are shorthand for what a witness is able to testify to or what a witness can decide not to testify about. Certain witnesses are privileged not to provide testimony. So that's why, in part, you have the word privileges. So spouses, wives, husbands, not quite yet with partners. For same-sex partners, I don't believe there's a case in New Jersey on this. So right now, I would say to you that same-sex partners, not privileged. Spouses are privileged. There was a case some years ago, I think it was called Sidney Riso. It was an Exxon executive who was kidnapped by a couple, a man and a woman, a wife and a husband. They kidnapped this Exxon executive. I think he lived over here in North Caldwell, in Tony Soprano country over there in northern Caldwell in Essex County. I think he resided there in a palatial home, and he was kidnapped by this husband and wife. I think their names were Marilyn and Irving Flax, but that's just my brain. I remember oddball facts. I could be wrong on that, but clearly that husband and wife were criminals, if not in this case, in some other case. So I will not have been speaking badly about them. They are criminals. But in any event, a husband and wife kidnapped Riso. I think his name was Sidney Riso. He's an Exxon executive. And when it came down to the trial, before they modified the law, and I think this was a federal prosecution in any event, not a New Jersey prosecution, but a United States Attorney's prosecution in New Jersey. Irving Flax, who was the male kidnapper, could prevent his wife, Marilyn, from testifying against him because there's a spousal privilege. That has since changed. There's still a privilege, but it belongs to Marilyn Flax. Irving and Marilyn are the husband and wife, right? The Bonnie and Clyde, or the Clyde and Bonnie. Now, if Marilyn wants to testify, or the spouse wants to testify, they can waive privilege and testify. But listen to the distinction one more time. The person who was being testified against, in this case it was Irving. Irving was going to trial. It might even have been a death penalty case. He might have killed the guy. We need to look it up. But in any event, Irving was the defendant. The United States government wanted Marilyn, his wife, to testify against him. Irving said, no way. I'm invoking privilege on behalf of my wife. Marilyn says, wait a minute, I want to testify. I want to get the good deal. The prosecutor's offering me, probation or some other lesser sentence. I want it. Irving says, no, I invoke the privilege. So either party could invoke the privilege before they changed the law. Either spouse is gender neutral, right? The man or the wife, the husband or the wife. That's changed now. Now, if a spouse wants to testify, they can. On the other hand, if a spouse doesn't want to testify, we cannot force them to testify in the state. They are privileged not to testify. Because as a matter of public policy, and all of these privileges are about public policy, every one of them has a greater good. Now, the greater good in the spousal privileges, we want husbands and wives to be candid with one another, share all of their intimate secrets, talk about everything and anything. That is the foundation of a good marriage, right? That trust that husbands and wives have. And if you have to worry that your wife will betray you, or your husband might testify against you in a criminal case, and if that's the way we put bad guys in jail in our country and in our state, then that would undermine the sanctity of the marital relationship. So the greater good here was the state's interest in preserving the sanctity of the marriage. And putting bad guys in jail takes a back seat to that public policy. But it wasn't that big a deal that the man or the woman can invoke the privilege on behalf of the other person. That's since changed. So same fact scenario, if Irving and Marilyn Flax kidnapped Sidney Riso, they get caught. Irving is in the court as a defendant. Marilyn could testify against him if she chose. On the other hand, she could say, I'm not testifying against my husband. I'm relying on my marital privilege. It's in her power to decide whether she takes the witness chair or not his power as it used to be. There's another privilege, and it's the only other privilege, but you know what? The newspersons one might apply that way as well. I think the newspersons and clerical. There's a privilege called clerical privilege. They used to call it priest-penitent privilege. Well, there's lots of spiritual advisors in this diverse world that we live in, right? So why should there be one that only protects Catholics? The priest-penitent privilege, right? So it's been changed. It's called the clerical privilege, or the cleric's privilege. And it protects religious advisors or spiritual advisors. In that case, the priest or the cleric can invoke the privilege, or the guy who's charged with the crime can invoke the privilege. It's kind of the way the spousal one used to be. Either party can claim the privilege. But in any event, what I want you to understand is not so much which privileges both parties have standing to assert the privilege, but that there are these privileges. And as the word privilege implies, certain witnesses are privileged not to testify, because the conversations that they have with the other party to the privilege are considered real important and confidential. You look at every privilege, it's about confidentiality and privacy. Attorney-client privilege. Well, you want the client to tell the attorney everything. If a client feels he can't trust his attorney, then they're not going to give the attorney the full story. And if the attorney doesn't have the full story, all hell can break loose in the courtroom. You certainly don't want half-truths or half information or three-quarter information if you're trying to represent somebody to the best of your ability and you're a defense attorney. So whatever conversations occur between an attorney and his client or her client are privileged. And the attorney cannot be forced to testify against the client in a future proceeding. Attorney-client privilege. Cleric-penitent privilege. priest, penitent, cleric, spiritual advisor privilege, right? Spousal privilege. These are privileges, okay? We want priests and rabbis and clerics to be able to advise their clients, their penitents, the persons that they guide and advise within their religion. We want them to be able to do that effectively and there to be trust. There's a great, I got to get it for the next Children of Justice. There's a great Seinfeld episode from the 90s where Elaine, who's one of the characters on Seinfeld, is chatting with a rabbi about her regret for never having married and for never having a steady relationship and whatever all of her neuroses are. And she is in fact jealous of one of the least persons you want to get jealous of on that show, this guy George Costanza, who's an oaf and a buffoon and a goofball, but he's getting married and she's not. And she feels badly that this buffoon is getting married and she's not. So she's chatting it up with this rabbi. Now they're sitting on the stoop, and this gets to, you need to be in a confidential relationship in order to have confidentiality applied. Okay, so that's one of the things Professor Myers talks about. It's just not the names that we have or the roles that people play. You have to be in a confidential relationship. To make the example, I could be in the doctor's office talking to the doctor about, some pains that I'm having, and I can confide in him about my personal life and my personal behaviors because I want to get treated. That's doctor-patient privilege, right? That's doctor-patient privilege. That's another privilege. There's no misunderstanding about the fact that we are in a privileged relationship. We're in a confidential relationship. Now, if I was at a bar, and I was at a hotel bar at a conference, and I ran into Dr. DeBellis, who you'll see testify in a little while, and I'm like, Julia, I got this pain in my back, and I've been doing X, Y, and Z lately, and maybe I shouldn't be doing X, Y, and Z lately. And she's like, well, I don't know. Tell me a little bit more about that. Can I have a scotch and water, please? A little less water? Yeah, tell me more about that. While I am telling my medical issues to a physician, I'm not quite in a protected relationship yet. Especially since I'm in a public place where there are third parties around. And that's another exception to these privileges and confidentiality, all confidentiality. Even if you are in a protected relationship, if you're making statements to that person and there's a third party around who's not part of the privileged relationship, then there is no privilege. So I'm kind of laying on a bunch of different concepts here. I'm going to tease them out for you to make it make more sense and get back to Elaine sitting on the stoop. The stoop is like a stairs in front of a home. It's a porch. It's Newark for, or I don't know what it is. That's Newark for a porch. Northeast. First of all, you need to make a privileged communication. You need to make a privileged communication to someone with whom you're in a privileged relationship, or substitute confidential. You need to make a confidential statement to someone that you're in a confidential relationship with, and there must be no third parties listening. Otherwise, the courts find that you don't have an expectation of what if there's a third party standing around? Privacy. If you're yakking away in front of third parties, then you don't have an expectation of privacy. So you need to make a confidential statement with someone with whom you're in a confidential relationship and have an expectation of confidentiality. Now, my example, talking to Dr. DeBellis, I may think I'm making a confidential statement. I may be telling secrets, but I'm not in a confidential relationship. Number one, I'm in a bar, standing there at the hotel bar, and number two, there's third parties around. So that could defeat the privilege. It could defeat confidentiality. Well, back to Elaine. She is chatting it up with the rabbi and she's telling about all of her regret that she's not married, and she's jealous of George, this oaf and buffoon. And the rabbi is telling everybody who will listen about what she said as gossip all over town. And she feels utterly betrayed by that. He's like, oh, you did not want me to share that, Elaine? You know. And while he was a rabbi and a cleric, and while she thought she was engaged in a conversation that was protected and spiritual, he didn't think so. Now, if you looked at it objectively, he should have thought so. But they're sitting on a stoop, on a porch. They're in broad daylight. Other people are walking by. So there's evidence to suggest that although Elaine might have felt that this was highly personal stuff, that there was not a complete privilege or confidentiality there because parts of the requirements were not met. Again, you need to make a confidential communication with someone with whom you're in a confidential relationship, and there can't be any third parties. That applies to all these confidential things, including privileges. So we started on the back end here this afternoon. Privileges are one source of confidentiality in New Jersey. Evidentiary privileges, privileges that apply in the courtroom or in legal proceedings. What is another source of confidentiality? What other thing or book or rules give relationships and records and discussions confidentiality? There's three of them. One was privileges. What's one of the other two?
Ethics.
Ethics. The ethical duty. And the ethical duty arises from, who makes these ethical duties, Teddy? Where
the professionals.
The profession itself. So if you're a nurse, the American Nurses Association has ethical obligations and ethical rules. The American Medical Association, the National Association of Social Workers, they may have special rules. Many social workers are licensed social workers. There may be rules that govern your licensure, right? That's an ethical duty that arises from the rules of your profession. And the last source of confidentiality is what? What makes DIFUS records confidential, Al? Statutes, laws that declare information privileged or confidential. So you have statutes, privileges, and ethical duties. Those are the three sources of confidentiality in New Jersey. Now, there are certain exceptions. Although there is confidentiality, although there is psychologist-patient privilege and confidentiality, and physician-patient privilege and confidentiality, if a psychologist or a social worker or a doctor of medicine learns from a client that he is abusing or has abused a child, does the doctor respect confidentiality, and is she obligated to respect confidentiality in that situation? Oh, you don't have your hand up? Well, what do you think? The doctor finds out that his patient is molesting his daughter. Does that guy have to report that to DIFUS, or could he say, or she say, oh, that's privileged, that's confidential, this is my patient, for Pete's sakes. How will patients ever trust me again? What wins, DIFUS mandatory reporting, or the privileges of confidentiality? DIFUS. Yay. The duty of mandatory reporting trumps privilege, trumps confidentiality every time. Every time. So your primary obligation is to report a reasonable belief of child abuse and neglect happening or has happened. If you look at it, has happened. So even stuff in the past. You have to report that to DIFAS. The privilege is what they call abrogated. Abrogated. A-B-R-O-G-A-T-E-D. Abrogated. The privilege is abrogated. It's chopped up a little bit. It's carved just a bit. Now, you read a case called State versus Smullen. Was it Smullen? Or Snell? Snell. Right. State versus Snell from 1998. That case involved the very issues that I just talked about. This was a psychiatrist who was treating a man. I think he sexually molested his granddaughters. It's been a long time since I read the case, but I think he got caught by his wife performing sex acts on his grandkids, and she made him go to the doctor, but it never went beyond that. And then the issue was whether the doctor had to report that to DIFAS. And the number one issue in this case was whether Dr. I think his name was Phillips Torrance or something like Phillips Torrance. Dr. Torrance is a physician, and he didn't want to testify for the prosecutor in the criminal case. Can someone tell me what the ruling was in this Snell case? Did Dr. Torrance have to testify for the prosecutor for molesting the little girls? Snell admitted to Dr. Torrance that he performed acts of cunnilingus on these little children. Was the prosecutor able to bring in Dr. Torrance to let the jury hear that he confessed? No. But hold that thought. No. Not quite. They might mention the case there. But this is about mandatory reporting in New Jersey. And about compelling someone by subpoena to testify in a criminal case. Was Dr. Torrance compelled to testify in a criminal case? Well, you got to read these cases, and it wasn't that long ago, but the answer is no. The answer was he didn't have to testify. Now, I argued, this wasn't my case, but I had argued before this case came down, and many prosecutors and DAGs argued similarly, that once the cat's out of the bag, once you are compelled to tell DIFAS, then the prosecution ought to be able to use that, because the cat's out of the bag already. Confidentiality has been pierced. We ought to be able to use that in the criminal prosecution. We also are compelled to be collaborative. Title IX compels the prosecutor's office to work with the Division of Youth and Family Services. There are a number of areas within Title IX and Title 30 that compel collaboration between the division and the prosecutor's office. But the court in Snell, which was an appellate division case, and it's never been overruled, was not impressed with those kinds of arguments. What they said was, the holding in the case was, their ruling was that Dr. Torrance and other persons who are in confidential relationships that learn about abuse or neglect of children have to report it immediately to DIFAS, like everyone else. And that the privilege or that the confidential relationship takes a backseat to the duty to report. The duty to report, said differently, the duty to report trumps or overrides or overrules confidentiality when it comes to telling DIFAS. On the other hand, the prosecutor cannot use that witness who reported the abuse, cannot use the professional in the confidential relationship as a witness in the criminal case. So in this case, the DAG could have taken action to protect those children in the civil family court, but the prosecutor could not force the doctor who called it in to testify in the criminal case. So you can use it in the civil case, but you can't use it in the criminal case. Now, that doesn't mean that Mr. Snell goes free. He can still be prosecuted. even though we would not have ever known about Snell being a molester if it wasn't for that breach of confidentiality. The only thing the court said was you can't force Torrance to take the stand. You can't force the doctor to be a witness and sit in the witness chair. But the prosecutor can open a case, and we can prove the case through independent evidence. And that's never really been fleshed out in the courts, but that's my interpretation of this case. Okay. What's clear is we can't use it. But what I think is the most persuasive way to interpret this is that we can certainly prosecute the case. We just have to do it through independent other evidence. And by other, I mean other than forcing a doctor to come in and betray his client on a witness stand. So do you understand the Snell case?
I kind of look confused. I have a question.
Okay.
You said the doctor cannot testify on the criminal case. But I guess, then what happens in the family case? You cannot bring him to testify.
Yes.
You can, yes.
Yes.
All right. Just making sure.
No, that's it. We'll start out, doctor, he meets in his little room and he provides counseling. All the doors are shut, the shades are down. Tell me about what happens with the girls. We're going to give you treatment. We're going to put you on this drug and that drug. It's confidential. Guy drops a bomb on him. Says, well, not only was I physically abusing him, I also had sex with him. Okay. He knows he's got to report it to DYFUS. So now they open the shades a little, and he goes and tells a third party. Tells DYFUS. Because there's a law that says you have to tell DYFUS. Once DYFUS finds out, Title IX says, call the prosecutor. Call the prosecutor. I pick up the phone and go, oh, what's the doctor's name? Bring him in. I want to interview him as a witness. That same guy, Dr. Torrance, the psychiatrist, he was a psychiatrist in this case, a physician, a medical doctor. It doesn't really matter as long as you're in a confidential relationship. The ruling of the court was I couldn't use Dr. Torrance as a witness in the criminal case to put Snell in jail, but the DAG could use Dr. Torrance as a witness against Snell in a civil case. Suppose DYFUS substantiated the abuse, and he goes, I want to find fact-finding. I never abused those kids. It's a lie, a pack of lies. I want a full hearing. I want a trial-type hearing. Okay, well, the DAG's got to put evidence on, right? Well, my number one evidence would be Dr. Torrance. And that's okay. So you can use it in a civil case, you can't use it in a criminal case. There was a man in the 1960s, the late 1960s. His name was, I think, Prajet Padar. Nijit. N-J-I-T, his name ended with. Padar. Padar was infatuated with a woman with the glorious name of Tatiana Tarasov. Okay? Now, Tatiana never even gave me the time of day. They both were at the University of Southern California. And she really was not interested in we'll call him Nijit Padar, at all. But he was certainly obsessed with her, to the point where he would secretly record her conversations with me. And he would listen to them over and over again, because her voice was that intoxicating to him. He was so obsessed with Tatiana. Well, eventually, he winds up in the office of a psychiatrist. He was acting out on campus, and he winds up in the office of a psychiatrist, and I believe he told somebody that he's going to kill Tatiana. Right? And they did a little something there. He went to the University of California, so the campus police had taken him. They got an evaluation, and then they let him go when they felt that he wasn't in danger, or it wasn't a problem, or whatever. And then he killed Tatiana. Well, that case is called Tarasov. Tarasov versus the Board of Regents of the University of California, I think, or something like that. We know it as the Tarasov case. And that's the duty to warn case. The question was, it's a question of civil law. The estate of, or Tatiana's family, sued the University of California for money damages. They said, our beautiful daughter died as a young woman, and somebody's got to be held responsible. And the University of California is partly responsible, as were a number of other defendants. The University of California says, wait a minute, we have sovereign immunity and a number of defenses. And one of the defenses was confidentiality. This Nijit Padar was in a confidential relationship with the psychiatrist. He couldn't breach that relationship. Well, in part, the ruling of the court was, and it was sent back to the trial court level, and I'm not sure what happened to it after that, but it stands for the proposition that where there is a grave potential harm to a third party, persons in confidential relationships, that's what we're talking about here, confidentiality, have a duty to warn the person who might be seriously injured. Now I'm going to say that in greater detail and in a way that you can jot down in your notes in a moment. But it's the duty to warn case. There were other cases that clarified exactly what this duty to warn ought to look like in California and in other states over the years. And in 2011, it looks something like this. And for your purposes, this is all you should remember about Tarasoff and the cases that followed. This is the rule of Tarasoff from me. A person in a confidential relationship has a duty to warn who? Readily identifiable third parties. Readily identifiable third parties. And we'll get in even deeper in a moment. A person in a confidential relationship, a professional in a confidential relationship, has a duty to warn, one, readily identifiable third parties, who are in grave or serious danger based upon a credible / believable threat that the professional learned in counseling or in the confidential relationship. So you need a readily identifiable victim or person who may be seriously or gravely harmed, and that information came from a credible threat, a credible or believable threat from someone in the confidential relationship. So the components are readily identifiable victim, serious harm, grave harm, and a credible threat. Now, if you flip it around, that's almost in the passive voice I deliver that. If you have a serious threat of serious harm to a readily identifiable victim, that flows a little bit better, right? If you have if you have a credible, believable threat of serious or grave harm against a readily identifiable victim, then you have to warn that victim. You have to take steps to warn that victim. What's going to happen? So, let's say I'm a psychologist and I'm working with a client, and he just got out of the Adult Diagnostic and Treatment Center at Avenel. He's done his sentence, though, and I'm providing aftercare, and the client says to me during the course of our confidential therapeutic sessions, the client says to me, you know what? I never would have gone to jail if I killed that bitch. She was nothing but a blonde whore, and I hate her. And this weekend, I'm going to rape a blonde and kill her this time so she doesn't live at the Willowbrook Mall. That's what I'm going to do. Well, and he says to his therapist, you look at me in the eye, I'm capable of doing it. I got a gun and bullets, and I'm going to do it. Seems to be a credible threat. Okay. Scary guy, he's got a history, it's a credible threat. Is it going to be grave harm or serious injury? He said he'll rape her and kill her. Do we have a readily identifiable victim? No.
But we have a threat.
I know. But who do we warn?
We don't warn anyone. We put it in the psychiatric report.
of things that probably could be done here, but I'm looking at this under a Tarasoff analysis. And the question is the psychologist obligated to warn someone? And in this case, 2 of the 3 components of Tarasoff are there, but one's missing. And the more difficult one, who do you tell? All the blondes in northern New Jersey? What about the ones over the county line, Rockland County and Orange County? What about them? Do we tell everyone in Willowbrook Mall? You don't have a readily identifiable victim. Suppose that we switch the facts around. Suppose that he says, this is never going to happen again. There's a young woman at the mall that works at the Bagel Nosh. She looks just like my victim. Her name is Mary Jones. She looks just like the victim in my last case, this Mary Jones. Every time I go have a bagel on Saturday morning, I talk to her. You know what? And take my word for this, I really mean it. It's going to happen. I'm going to go there and I'm going to punch her in the arm. Take that to the bank. It's going to happen. Well, you got a serious, credible threat. You got a believable threat. You got a readily identifiable victim. You know her name, Mary Jones. She works at the Bagel Nosh. She works at Willowbrook Mall. We know who to warn. But you got a punch in the arm, man. That's not grave, serious injury, right? So Tarasoff fails again. You need a readily identifiable victim. You need a credible threat, and you need it to be a threat of serious harm, grave danger, in order to pierce confidentiality and betray the trust of a client. And that credible threat's important because lots of people say lots of stuff in therapy that many therapists are able to evaluate and say, you know what, this is acting out. He doesn't mean it. I mean, it's a risk when you conclude that, but you have to be satisfied that the threat is credible. So, Tarasoff versus the Board of Regents of the University of California, we understand that case? Okay. Any questions about that? Go ahead.
Do you only have to tell the identifiable victim? Would Tarasoff be satisfied if you just told that person?
No, I don't think that's it. I think you need to tell the victim and persons and institutions in a position to protect that victim from that harm. So if the victim worked at Willowbrook Mall, let's say, in my hypothetical, you would probably tell the victim as well as mall security. And if she lived in Fairfield, New Jersey, maybe the Fairfield police. I think you need to share that information with a person or persons that are able to protect that victim from harm or from the acts of this guy in therapy. Any other questions? Speaking of privileges, see this? There's a social worker privilege. In the rules of evidence, there's a privilege. Social workers cannot be compelled to testify against their clients, except in certain circumstances. Of course, there's exceptions. If it's required by law. Here's a Tarasoff-inspired subsection. B says, failure to disclose the information presents a clear and present danger to the health and safety of an individual. And I'm glad I read that, because that 3-pronged Tarasoff analysis, you need to add prong 4. I messed up. The danger has to be imminent. So we said it has to be a readily identifiable victim, a credible threat of serious harm, but that serious harm has to be imminent. So to mess around with that hypothetical, I'm going to get that Mary Jones in 2013. That's not an imminent threat, right? So that's the 4th prong of that Tarasoff rule. And this is in our social worker privilege here, similar to Tarasoff, where there's a clear and present danger to the health and safety of any individual. So the social worker privilege has a Tarasoff-like exception in subsection B. Subsection D, the patient or client is a defendant in a criminal proceeding, and the privilege would violate the defendant's right to subpoena witnesses for his benefit or her benefit. So you can compel the social worker to testify if you're a criminal defendant, but certainly not the prosecutor. The antidote to all these privileges are, and the antidote to all confidentiality, is a waiver. If the person that's protected by the privilege waives the privilege, or waives the confidentiality, or gives it up, then you don't have any problems. Often we subpoena records from the schools in our criminal cases. And I'd say 99% of the lawyers don't object. The schools just give us the records. Well, in Title 18 of the United States Code, these education records are protected by statutes. The source of education records confidentiality are United States statutes. There's one or two board attorneys that objects when we subpoena or ask for these records, and he won't turn them over. And he's right. There are confidential rules in the United States Code. Now, I believe that Title IX and Title 30 allows me to get those records despite Title 18 of the United States Code. But rather than get into a legal battle with these lawyers, I just go to the family of the victim and get a waiver. I get a piece of paper saying, I don't object to these records being shared with the prosecutor in my case. That's the end of the privilege. That's the end of confidentiality. Because the person protected by confidentiality says, I waive confidentiality. I give it up. So that is a way to deal with requests for confidential information, short of looking up the law and finding an exception, or where there is no exception and you need the records. And DAGs know how to do that. Prosecutors know how to do that as well. What if you get a subpoena? What if you get a subpoena for records? You get a subpoena for records and you say, well, I've read the subpoena and it's, as Professor Myers points out, it's a rather formidable looking document. It compels me to be at the courthouse under pain of contempt of court on the 18th of June 2011. And if you don't produce the records, you can face punishment by law. You can get these subpoenas in the mail, and you can read them, and you can get intimidated by them, because they're legal documents that talk about being incarcerated if you don't comply. As Professor Myers points out, and take it from me, I'm not telling you not to comply, ultimately, but don't comply until you talk to a DAG or supervisor, because these subpoenas, they used to be in books as subpoenas. You buy them at the stationery store. Lawyers would buy them. They were manufactured by Allstate Legal Forms and Supply Company. And you get a book of them, and you can just fill them out with a pen, type them on a typewriter, and hand them out. Lawyers are empowered by the rules of court to subpoena stuff. But that doesn't mean they know what the hell they're doing. You know, they get the book, they want something, they just fill out the subpoena and hand it to you or deliver it to you, or have some sheriff's officer deliver it to you. It seems officious. It is official. But sometimes they subpoena things that are protected. And sometimes the confidentiality clearly outweighs the subpoena power. So how do you deal with that? Well, the first thing that you do, always, is to talk to a supervisor or to talk to an attorney who represents the institution in which you are a child advocate. Whether you're a DIFAS worker or a teacher or a daycare center operator or a social worker at the hospital, you talk to the hospital's attorney, you talk to your supervisor. What you don't do is hand over the records. I don't care if there's a red ribbon and a wax seal and there's the King of England's name's on there, or Queen Kate. You don't turn over the records. You talk to a supervisor. Sometimes, if you are comfortable doing this, you might want to call the lawyer. If you are a veteran DIFAS worker or child advocate, because when you call the lawyer, you go, what are you doing here? I can't turn these records over. What are you looking for? And they say, well, I'm looking for the records of when you counseled her when she was in a car accident. Oh, I don't know anything about that. I've never counseled her. when she was in a car accident. And then the lawyer might bark up a different tree. Now this would be more for a private entity, where time is money, where legal counsel is money. You know, if you're a small private practice, rather than go hire a lawyer, picking up the phone, but you got to be careful. Because lawyers can be slippery. They're like news reporters. Well, was she ever there? Can you tell me a little bit more? Well, can you know, is it bigger than a bread box or smaller than a bread box? You know, they kind of get you to say what it is you're not supposed to say. So you run that risk. You need to be firm. And the other thing is, perhaps the best advice is call your client, man. Talk to the person who's protected by confidentiality. Now again, this doesn't apply too much to DIFUS. You know, you have a process and a protocol. You have DAGs who represent you. But for child advocates who are private practitioners, you call your client, go, hey, this lawyer, and they may go, no, I want him to have the records. I'm suing for X or Y, or my mother's suing. Talk to my mother. The mother says, I want him to have the records. So sometimes the telephone can be helpful if you get a subpoena, but be careful. And if you don't abide by a subpoena, it is contemptuous. You can be held in contempt and incarcerated. So it is serious.
For mental health, it has to come from the judge, right? I mean, if it's just from the lawyer, how much weight does it carry?
Yes, that's the end of what happens. If you don't abide by the subpoena, then they compel you to come to court and explain yourself, and you know it's never going to be a real issue. So I would err on the side of not turning over the records and seek advice and counsel from others. And if you are savvy enough, talk to the other lawyer and talk to your client. Okay? So we were looking at the social worker privilege. The other thing we hear a lot about is this HIPAA. And HIPAA is the Health Insurance Portability and Accountability Act, and it was passed in its current incarnation in 2002. And, you know, you can't walk into a hospital ER without seeing all kinds of HIPAA stuff. And basically, the federal government tightened up the rules of confidentiality and privacy with regard to our personal health information, our medical records. This was really all about managed care and insurance companies. Nevertheless, it applies broadly in a variety of contexts, but in part it was inspired by issues surrounding those kinds of managed care programs. What I'd like to point out, though, is there are exceptions in the law, and they are outlined in the reading that we provided to you. There are a number of exceptions that protect law enforcement officials as well as social workers. Required by law or mandatory reporting laws are covered. That's an exception to HIPAA. It's built right into HIPAA. And there are a number of exceptions that have to do with criminal investigations and criminal cases. Victims of crime. There are exceptions for victims of crime and the like. And the point I want to make without getting deep into the HIPAA law is that people can say, oh, HIPAA this, HIPAA that. It has to apply. And in the business of child advocacy and protecting kids, the Division of Youth and Family Services and law enforcement in New Jersey are empowered to get most medical records by subpoena because there are specific exceptions in the Health Insurance Portability and Accountability Act. Things have settled down. In 2003 and 2004, people didn't want to share anything anymore. It was like, HIPAA, HIPAA. But the limits of this statute became a lot more clear as people became more experienced in its application. I'm going to show you a couple of video clips on confidentiality. So let's see. No, I guess not. Here we go. This one on.
Rico,
You tell us.
I don't see anything for David Moore. Can I see that charge again? $112, no copay. Here we go, $112 for Joan Moore. First-time prescription for Soledgeline.
What's that for?
Depression, among other things. You'd have to ask her doctor, Dr. Richard Shipman. Right around the corner on 93rd.
You think there's a confidentiality issue in that discussion? Thank you very much, Priscilla. Diagnosis, doctor, address, and opined on its utility and what the... You think that happens once in a while in real life?
Yeah.
All the time. But, clearly that is a violation of doctor-patient confidentiality, and I'm sure there is an ethical duty that pharmacy workers and pharmacists are held to as well.
You can't tell us why you might have prescribed Soledgeline for her?
I'm not even going to confirm whether or not she's a patient. I wish I could. I'm sorry, doctor-patient privilege.
Well, her privileges have been suspended, Doc. She's lying in a coma at Stein Memorial.
What? How did that happen?
Well, so she is a patient. She had an insulin overdose from an injection. God. This drug you were giving her, was it for depression?
That's it. We're done. I had a patient to me. Don't forget about the one in a coma.
This is going very well.
So there, that doctor, this is the same case that the pharmacist was talking about with Soledgeline. He respected, in large part, he respected the privilege and invoked it on behalf of his client, which was the appropriate thing to do, even if the police come a-knocking.
Does the behavior of the doctor kind of give it away that?
Well, yeah, I mean, that's what was funny about it, yeah.
Accepted utterance.
Yeah. By the way, confidentiality applies not only to the doctor, but to the treatment team also. And by that I mean it applies to the physician or the psychologist or even the DIFUS worker and the group of people that might help that professional, paraprofessionals and support persons. So if you go in to see Dr. So-and-so, but you meet with a nurse or you meet with a physician's assistant, any information that's shared with the physician's assistant or the nurse is also covered by the doctor-patient privilege or doctor-patient confidentiality. Those are third persons that are among the treatment team. They are not third persons that override the privilege. So if you have a professional, and that professional relies upon other paraprofessionals as part of a group of people who engage in professional therapy or professional services, everyone in that group is in a confidential relationship with the client. Okay?
Can I invoke my right for them not to testify?
If you're in a confidential and privileged relationship with your doctor, and the doctor's prevented from testifying, then you can prevent the nurse from testifying, the physician's assistant from testifying, anybody in the doctor's working group that you went to for treatment and had a confidential relationship with. Any other questions on confidentiality? Okay, we're going to look at another video clip as we move on to Learning Module 8. And in Learning Module 8, we're going to learn about different kinds of witnesses. Now, this video is a little bit more fun than the others, but it makes some good points about what we're going to talk about today. Expert witnesses.
First witness, Ms. Mona Lisa Vito.
I object, Your Honor. This person not on the witness list.
This witness is an expert in the field of automobiles and is being called to rebut the testimony of George Wilder. Your Honor, would you please instruct the bailiff to escort Ms. Vito to the witness stand, please?
Hold up your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yeah. Ms. Vito, you're supposed to be some kind of expert in automobiles, is that correct? Is that correct?
Will you please answer the counselor's question?
No, I hate him.
May I have permission to treat Ms. Vito as a hostile witness?
You think I'm hostile now? Wait till you see me tonight.
Do you two know each other?
Yeah, she's my fiancée.
Well, that would certainly explain the hostility. Your Honor, I object to this witness. Improper foundation. I'm not aware of this person's qualifications. I'd like to voir dire this witness as to the extent of her expertise. Granted. Mr. Trotter, you may proceed. Oh. Ms. Vito, what's your current profession?
I'm an out-of-work hairdresser.
Out-of-work hairdresser. Now, in what way does that qualify you as an expert in automobiles?
It doesn't.
Well, in what way are you qualified?
Well, my father was a mechanic. His father was a mechanic. My mother's father was a mechanic. My 3 brothers are mechanics. 4 uncles on my father's side are mechanics.
You know, your family's obviously qualified. But, have you ever worked as a mechanic?
Yeah, in my father's garage, yeah.
As a mechanic? What do you do in your father's garage?
Tune-ups, oil changes, brake relining, engine rebuilds, rebuild some trannies, rear end.
Okay. But does being an ex-mechanic necessarily qualify you as being an expert on tire marks?
No. Thank you. Goodbye.
Sit down and stay there until you're told to leave.
Your Honor, Ms. Vito's expertise is in general automotive knowledge. It is in this area that her testimony will be applicable. Now, if Mr. Trotter wishes to voir dire a witness as to the extent of her expertise in this area, I'm sure he's going to be more than satisfied.
Okay. All right. Now, Ms. Vito, being an expert on general automotive knowledge, can you tell me What would the correct ignition timing be on a 1955 Bel Air Chevrolet with a 327 cubic inch engine and a 4-barrel carburetor?
It's a bullshit question.
Does that mean that you can't answer it?
It's a bullshit question. It's impossible to answer.
Impossible because you don't know the answer.
Nobody can answer that question.
Your Honor, I move to disqualify Ms. Vito as an expert witness.
Can you answer the question?
No, it is a trick question.
Why is it a trick question?
Watch this.
The Chevy didn't make a 327 in 55. The 327 did come out till 62. And it wasn't offered in the Bel Air with a 4-barrel carb till 64. However, in 1964, the correct ignition timing would be 4 degrees before top dead center.
This is a picture taken by my fiancée outside the sack of suds. We agree on this?
Yeah.
Yep. I'd like to submit this picture of the tire tracks as evidence.
Mr. Trotter?
No objection, Your Honor.
Ms. Vito, did you take this picture?
You know I did.
And what is this picture of?
You know what it's of.
Ms. Vito, it has been argued by me, the defense, that two sets of guys met up at the sack of suds at the same time, driving identical metallic mint green 1964 Buick Skylark convertibles. Now, can you tell us by what you see in this picture if the defense's case holds water? Ms. Vito, please answer the question. Does the defense's case hold water?
No. The defense is wrong.
Are you sure?
I'm positive.
How could you be so sure?
Because there is no way that these tire marks were made by a 64 Buick Skylark. These marks were made by a 1963 Pontiac Tempest.
Objection, Your Honor. Can we clarify to the court whether the witness is stating opinion or fact?
This is your opinion?
It's a fact.
I find it hard to believe that this kind of information could be ascertained simply by looking at a picture.
Would you like me to explain?
I would love to hear this.
The car that made these two equal-length tire marks had positive traction. Can't make those marks without positive traction, which was not available on the 64 Buick Skylark.
And why not? What is positive traction?
It's a limited slip differential which distributes power equally to both the right and left tires. The 64 Skylark had a regular differential, which anyone who's been stuck in the mud in Alabama knows. You step on the gas, one tire spins, the other tire does nothing. That's right. No, there's more. You see, when the left tire mark goes up on the curb and the right tire mark stays flat and even, well, the 64 Skylark had a solid rear axle. So when the left tire would go up on the curb, the right tire would tilt out and ride along its edge. But that didn't happen here. The tire marks stayed flat and even. This car had an independent rear suspension. Now, in the 60s, there were only two other cars made in America that had positive traction and independent rear suspension and enough power to make these marks. One was the Corvette, which could never be confused with the Buick Skylark. The other had the same body length, height, width, weight, wheelbase, and wheel track as the 64 Skylark, and that was the 1963 Pontiac Tempest.
And because both cars were made by GM, were both cars available in metallic mint green paint?
They were.
Thank you, Ms. Vito. No more questions. Thank you very, very much. You've been a lovely, lovely witness.
Mr. Trotter? Mr. Trotter? No, Your Honor. No further questions.
In that case, Your Honor, I'd like to recall George Wilbur.
Ms. Vito, you can stand down. You realize you're still under oath?
Yes, sir.
Mr. Wilbur, how'd you like Ms. Vito's testimony?
Very impressive.
She's cute too, huh?
Yes, very. This Gambini?
Sorry. Mr. Wilbur, in your expert opinion, would you say that everything Ms. Vito said on the stand was 100% accurate?
I'd have to say that.
And is there any way in the world the Buick that the defendants were driving made those tire tracks? Come on, you could say it's okay, they know.
Actually, no.
No. Thank you. No more questions.
My recollection was that Marissa Tomei, who played Miss Vito, that she won an Academy Award, and I don't believe that anybody has ever won an Academy Award for a comedy as Best Supporting Actress ever, other than her. But she really nailed that role, and it's pretty funny. What's going on here? It's a pretty funny video clip, but the reason that I introduced the subject of expert testimony with that clip is because not only did Marissa Tomei nail the role of the 1980s out-of-work hairdresser who's an expert in car mechanics and general automotive mechanics, but it also nails the concept of expert witnesses pretty well. It does a nice job with that. There are two kinds of witnesses in the courts, both civil and criminal. There is the lay witness, L-A-Y, lay witness, and there is the expert witness, the expert witness. The lay witness and the expert witness. Now, a lay witness, as you can see from this slide I put up, is a witness that testifies about what they saw, what they heard, what they felt, what they smelled, something that they can testify about that they experienced through their senses. It's a witness that's involved in the case. If they saw the shooting, or they're the victim in the case, or they know one of the parties and they're providing evidence about that person. Okay, that's a lay witness. An expert witness sometimes knows nothing about the case. But they are typically brought in to testify in the form of an opinion or to give the jury information that helps them evaluate evidence. So a lay witness is a witness that's involved in the case, that's seen something or heard something or experienced something. An expert witness comes in to testify about things that are beyond the understanding of the jury. They give an opinion to the jury, or they give them information that helps them understand what the case is all about. Now, in order to be an expert witness, you simply need to know more than the average person about the subject that's relevant. So you don't have to have any special degrees or any special background. You need to know a little bit more than the average person about a subject that's relevant to the case. Professionals who have experience are often better witnesses than academics or people that have a number of degrees. Book learning, academic degrees are helpful, but I would suggest to you that meaningful experience in the field for which the experts testify is the most persuasive and the best kind of basis to allow an expert to testify. The bottom line is anybody who knows a little bit more than the average person or the jury can be an expert. I had an evidence law professor that gave the example of a little boy named Billy who collects butterflies. If we learned that 12-year-old Billy has been collecting butterflies since he was in the 3rd grade and he was 9 years old, for the past 3 years he's collected butterflies in the Little Falls, Clifton area, and he's read 10 books about butterfly collecting. He's watched documentaries about butterfly collecting. He's caught butterflies and cataloged them in the Little Falls, Clifton area. Well, little Billy knows more than the average person about butterflies in the Little Falls, Clifton area. He's read books. He's cataloged them on his own. He's collected butterflies. He's done this for the past 3 years. He knows a little bit more about butterflies. So if there was an issue in a case about whether a monarch butterfly was seen on the campus of Montclair State University, and if that was relevant and important, and if that changed the case in some way, well, little Billy might be able to come in and testify that there ain't no monarch butterflies in this area. So someone may have seen a butterfly, but it was not a monarch butterfly. Because monarch butterflies are not indigenous. They're not found in the Little Falls, Clifton area. They're only found in Southern California. Now, I'm making all that up, but if that was true, little Billy could come in and give his expert opinion. I mean, he's collected them for 3 years. He's collected them right in this area. He's studied them. He's made charts. So he doesn't have any alphabet soup after his name, right? He doesn't have MD, PhD, PsyD, DDD, DDS,
DYFS.
DYFS. All that stuff can be helpful, but what's really important is experience. So little Billy knows a little bit more than the average person about butterflies in this area, so that might make him an expert witness. And going back to the Miss Vito expert testimony in the My Cousin Vinny clip that we saw, you will see that she has lots of experience, although the prosecutor was skeptical and demeaning in his questions, and shocked when he learned that she has not only worked in her uncle and father's garages, but has rebuilt engines and rebuilt transmissions for a period of years. So despite the fact that she is primarily a hairdresser who's not working at the moment, she also is an expert in general automotive mechanics. No doubt about it. And the defense, actually the prosecution, makes the case for the defense. An expert has to be qualified, and that's what happened with Ms. Vito. In that case, by the prosecutor questioning her, he qualified her. Typically, the Joe Pesci role, the defense lawyer, would qualify the witness. And by qualifying the witness, we mean you have to develop evidence for the judge about the witness's expertise. The judge isn't just going to put little Billy on the witness stand and allow him to give his opinion about butterflies. The judge is not going to just let anybody testify about general automotive mechanics. It has to be someone who at least is able to demonstrate superior knowledge, or that they know more than the average person. So the first step in that process is called qualification. And that was done through the prosecutor, who questioned Ms. Vito at length about her experience in this field. And it was apparent to everyone, including the court, at the end of that voir dire. Voir dire is a French phrase that is used within the law, and it loosely means to question somebody. So during that questioning, or voir dire, the prosecutor demonstrated that Ms. Vito was competent to be an expert. She was qualified to be an expert. So before they can give their opinion about monarch butterflies or tire marks or general automotive mechanics, you have to be qualified. And that happened. You saw something else that experts do when you watch Ms. Vito testify. She looked at the picture and she gave an opinion. She tells the judge, who's since passed away, that's Herman Munster, by the way, if you ever watch the old Munsters. That's Fred Gwynn, plays the judge. And in the old 1960s television program that you can watch on Netflix. And he was in Car 54, where are you? Anyway, he passed away, but Fred Gwynn is the judge. And she tells the judge, she looks up and says, when he asks her, is that your opinion? She looks up and goes, that's a fact. Well, expert witnesses aren't allowed to say things like that. That part is Hollywood. But they're allowed to give their opinion. They are. And they're one of the very few kinds of witnesses that are allowed to give opinions. You know, if you bring in the aunt in a child abuse case to family court or to criminal court, she can't go, well, you want my opinion? He didn't do it. You want my opinion? She's a liar. You want my... No. We just want the facts. You're allowed to come in and state facts in the courts of this state. Okay? You're not allowed to give opinions. Once in a blue moon, you can give opinions. But generally, a witness is allowed to give opinions about things that are common knowledge. Things that the jurors can size up on their own. For example, you can give your opinion. Any witness can give their opinion about distances. Well, how far away was she standing when this happened? About 5 feet. Well, that's an opinion, right? How fast was the car going? Well, it was going at least 60 miles an hour. That's an opinion. Those kinds of everyday opinions, they're admissible. But opinions about facts that are relevant and important to the case, that is not permissible ever. The exception is the expert witness. The expert witness can give an opinion. And if we look at Ms. Vito, her opinion was that a car with posi-track rear suspension made those skid marks. She had an opinion about the kind of car that made those skid marks. And that was real important because these boys were accused of, young men were accused of committing a robbery at the Sack of Suds, which was a gas station and convenience store in Alabama. And they were from New Jersey, and they were headed, or New York, and they were heading south. And this is one of these fish out of the water kinds of movies, right? They're in Alabama, where the culture's a bit different, and they're in North Jersey. So she says a certain kind of car made these skid marks. But what's very important is she gives the basis for her opinion. And here's why. That's what he goes, I'd sure like to hear this. And he puts his legs up. You want me to tell you? He says, how can you be so sure about that? And she says, would you like me to tell you? And he says, I would love for me to tell you to tell me. Puts his legs up. The expert gets qualified. They give an opinion. And then they give the basis for their opinion. And then she tells why. The kind of car that would make this kind of skid mark was this kind of car. There were certain kinds of cars that had limited slip differential. That's where the power goes to the tire that needs it. And she explained all about cars and the kinds of cars that were available in the 60s, the kinds of cars that have posi traction, limited slip differential. And then she had a conclusion, and that was her opinion that whatever the car couldn't have made the skid mark that belonged to the young men. That's the way expert testimony works. There were a lot of other legal issues in that clip that are on the money. For example, defense lawyer Joe Pesci shows the photo to the prosecutor and says something defective. Can we at least agree on this? That happens all the time in court. You have to do that. You just can't give a piece of evidence to a witness without showing it to the other lawyer and then getting that witness to authenticate it. Now, we're not going to go into this kind of stuff here in this class. It's not that kind of training. But the authentication process means that the witness looks at it and has to describe what it is. It's a photo. I took it on the 25th of March at 6 o'clock in the afternoon. It depicts Grand and Market Street in Patterson. You need to describe for the record what the hell the thing is. That's why the Joe Pesci character is trying to get Miss Vito to authenticate the photo. And he's going, what is this a picture of? And she goes, you know what it's a picture of. But what is it a picture of? You know very well what it's a picture of. You took the picture. She should have described the picture, the circumstances under which the photograph was taken, what it is a photograph of, what the conditions were that day, what the weather was, and all that kind of stuff. Back to the expert witness. It says an expert witness gives an opinion or gives the jury information that helps them evaluate evidence. So there's two kinds of experts that you will encounter in child advocacy. The expert that gives an opinion, like Miss Vito, or the expert that educates the jury. And I'll explain what that kind of expert does in a moment. The expert who gives an opinion, like Miss Vito, for example, may be a pediatrician. Let's say there's a child who has a fractured femur or thigh bone. Let's say it's a spiral fracture of the femur, and the child is 2.5 months old. So, let's say that the caregiver who had exclusive control of the child, who was taking care of the child and was the only adult who had control of the child at the time that the injury occurred, tells the social worker at the hospital that the baby fell off a changing table. The changing table was about 3.5 feet high. And it happened in her living room, and on the living room, the DIFUS workers went out and they took a look at the carpeting, and it was a deep pile shag carpeting with deep pile fibers. So we know, in this case, that there was a fracture of the thigh bone of a 2.5-month-old that fell off a 3.5-foot changing table onto a carpeted floor with deep pile carpeting. Or, see, this is not deep pile I'm walking on here. This is indoor-outdoor junk on the floor here. This carpeting is thick pile and fiber. The doctor comes in and says, in my opinion, the caregiver's story is inconsistent with medical facts. The caregiver's story is not plausible. The caregiver's story is not consistent with the injury. That's like saying the car did not make these tread marks. Some other car did. That's Ms. Vito's opinion. The doctor's opinion is the caregiver's story is not consistent with the medical evidence. So that's the conclusion. That's the opinion of the expert. Now, Joe Pesci puts his legs up and says to Dr. DeBellis or Dr. Shaw or Dr. Finkel, I would really love to hear this. What makes you say that? What's the basis for your opinion? That's the next step. So the physician would say, here's the basis for my opinion. The conclusion, and then the physician has to explain what makes them say that. What's the basis for their opinion that the caregiver's explanation is inconsistent with the medical evidence. And the doctor might say something like, well, first of all, thigh bone fractures or femur fractures are very rare in 2.5 months old children. We see those fractures in children that are ambulatory, kids that can move around, can walk. Number one. Number two, this is a spiral fracture. Spiral fracture requires some kind of opposing forces, some amount of torque. It's usually a fracture that involves from applied pressure. But in this case, the caregiver tells me that the child fell from a changing table onto the carpeting on the floor. A fall from 3.5 feet to the carpeting on the floor would not produce the kinds of opposing forces and torque to cause a spiral fracture. This injury happened some other way. It did not happen from a fall from a changing table about 3.5 feet. That's my opinion. That's my opinion. And they wouldn't say it that bluntly, but that's what's happening there. the doctor's giving her opinion about the cause and mechanism of injury. And also opining, or giving her opinion, that the caregiver's explanation is implausible. It's wrong. Doesn't make any sense. It's contrary to medical science. Change it around. Dr. Shaw from the Central Diagnostic Center over at Robert Wood Johnson and St. Peter's over there in Middlesex County. Dr. Shaw comes in. She testifies that she examined Gabriella. Gabriella came in for a medical examination, and during the medical examination, she had the opportunity to examine her vagina, and there were notches at 9 o'clock and 6 o'clock, little marks that were the residual of trauma on the hymenal tissue in her vagina. Okay, that's her finding. Tell us more. It is my opinion that there was some kind of penetrating intrusion into her vagina. And that's pretty much it. That's all the doctors are giving. She's not going to say what it was a penis, a pencil, a finger, whatever. But for DAGs and prosecutors, it doesn't matter. There's evidence of some kind of trauma to her hymenal tissue. Very, very rare, by the way. But for purposes of this discussion, in that situation, the expert witness will be giving her opinion about her findings. And her opinion is that there was some penetrating injury. That it's not normal. You don't see notches at 3 o'clock and 6 o'clock on normally developed female children at this age. That it's unusual, abnormal, and was caused by some sort of intrusion, some penetrating intrusion. That's an opinion, and then they give the basis for their opinion. That it's not normal, that I read 100 articles, that I examined 1,000 kids, and the normal hymenal tissue looks like this. In this case, this hymenal tissue has notches in it. Those notches are consistent with penetrating injury. That's the basis for my opinion. So that is an expert pediatrician in both cases who gives an opinion. Now, she wasn't there when the kid fell off the changing table. She's brought in, okay, as a medical expert because she evaluated the child later, so she's part fact witness, but primarily an expert witness in this context. The other way a person can be an expert is to give the jury information to help them understand an issue that's important to the case, that's highly relevant, that's important to the case and relevant. But the jury may not understand about this issue. It may be beyond the average person's understanding, and that's what gets you into the expert realm. If it's something that's beyond the average person's understanding. For example, we investigate and prosecute periodically possession of child pornography cases. We need an expert on computer forensics to come in and explain to the jury about how people can acquire images from the internet, how file sharing works. Because one of the issues in a possession of child pornography case is possession. You need to knowingly possess child pornography. So many times the defendant says, I didn't know that was there. It wasn't my purpose to have that. I just look at regular porn, and somehow they send me this stuff, and I immediately delete it. That's a very appealing defense. And it may be true for many people. But once a forensic scientist or a computer expert looks at that computer, he may be able to evaluate that computer and give an opinion about whether that child pornography was possessed for a millisecond or longer. If the point was that he looked at it and deleted it once he realized what it was, we can figure out whether that happened that way. So in that case, he'd be giving an opinion. Supposing that wasn't the issue at all. Supposing the jury just needed to know how people download child pornography. Well, the expert might come in and only explain how email works. Now, most of us, all of us know what email is here. You can't assume that the jurors know exactly what email is. There could be people that don't even use email. You need to explain things to the jury sometimes. how email works. I'm sure you guys don't know how peer-to-peer networking works, or peer-to-peer file services work. Lots of these guys who share child pornography use peer-to-peer. It's a form of file sharing. It used to be they'd use, and people used for music and pictures and videos, Kazaa, and LimeWire, Napster 15 years ago, 12 years ago. But peer-to-peer works a little bit differently. So an expert might come in and explain what peer-to-peer means. He doesn't talk about the case at all. He just explains how people get stuff from the internet and put it on their computer. So they would not give an opinion, they would just give information. One time I had a guy, this guy, Griffin Littell. Griffin Littell molested his two stepdaughters. One was 8, the other one was 9, something like that. And he molested them in the shower after they went to the beach. And he would help them dry off when they got out of the shower after they went to the beach. And his defense was, get this, why he would be helping these perfectly able children towel off on their naked bodies is one issue. But his defense was sometimes the sand would get in their cracks, and I had to get in there and help get the sand out of their cracks. Well, you can't make this stuff up. This is a man, Griffin Littell, that we prosecuted. But it gets even better. His wife, who dumped him immediately, one of these great spouses who believes the children immediately and dumps them, she came to me shortly after the arrest and she said, you know, I want to give you some stuff that may help you in your case. And I said, well what is it? Very often when citizens bring stuff, it's not very helpful, but you be respectful to them and tell me what it is. Well, Griffin had this briefcase with all this dirty stuff in there. I go, what are you talking about? Oh, he had Benoit balls and handcuffs and S&M stuff. So he was into sadomasochism and kinky sexual stuff. Oh, yeah, and there were newspapers in there. This was 15 years ago. The internet, you can find whatever you want in the world now on the internet, but he had these newspapers back then where he would circle advertisements for kinky sex with people in Lower Manhattan and wherever. So I said, listen, you know, he could be kinky, he could be into, you know, unusual sexual practices, even deviant sexual practices, but there's not a significant correlation between deviant sexual desire and child molestation. I mean, just because someone likes to get tied up or do whatever, you know, Griffin would do, doesn't mean he molests kids, so it's not going to be admissible. So, you know, I gave her back this briefcase with these things in it. She said, well, she goes, well, there was this book too, I guess that wouldn't be helpful either. I said, what book? I really didn't think anything of it. She said, well, on Megan's 13th birthday, Griffin gave her a copy of the book Lolita. I said, he gave her a copy of the book Lolita on her birthday? On her 13th birthday? Yeah. I said, do you still have the book? Oh, yeah. He wrote something on it. Bring me the book. She brings the book. Now, this is relevant. This is relevant. She brings me the book. I open the book, and on the title page, it says, to my dearest Megan, on your 13th birthday, love. And this is her father. He raised these little girls when they were little babies. The only father they ever knew. To my dearest Megan, on your 13th birthday, love, Griff. 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 It's your father, Griff. Let us with this guy, Griff. My problem was, I was really excited about this piece of evidence. I thought this piece of evidence was compelling. I thought the fact that he gave his daughter, on her 13th birthday, the birthday of her entering into puberty and into the teen years and blossoming and flowering, this book called Lolita. I thought it was relevant, but I couldn't assume that the jury knew what the hell that book had to do with anything. I'm confident that most of you don't know why I was so into getting this book into evidence. Tell the truth. How many people, just the people who know, how many people here know what the book Lolita is about? Lolita. Okay, maybe about almost, not quite a half. Not quite a half. So I needed somebody to explain to the jury why this was relevant. I needed an expert witness to give information to the jury to help them evaluate the evidence. Because I knew, and I really didn't understand Lolita completely, but it's been the subject of movies, cartoons, comedies, high drama. One of the most famous movies starred an actor named James Mason that was very popular. There were treatments of it in the 70s, 80s. Nearly every decade you see a new version of Lolita. And it is a book by a famous Russian author named Vladimir Nabokov. It's considered one of the great classics of fiction ever written, Lolita. And it's about a middle-aged man who's sexually fascinated and obsessed with a 12-year-old girl. That's what the book's about. So I call up here, Montclair State. I call up William Patterson. I call up a couple other colleges in the English department. And I say, I want to talk to someone who taught the book Lolita, because I want to put them on the witness stand as an expert witness in the case of State versus Littell. And I found an English professor at William Patterson, who I told him, look, we can't pay you, but if you're involved in a criminal case, he's like, I should teach the book. I'd be happy to be an expert witness. And I'm like, this is great. Now, that was what I wanted to do, but there's another lawyer in the courtroom, and he's like, this is outrageous what he wants to do. Who is he to bring in this man to say what a book's about? People's interpretations of literature is very personal, it's very subjective. Who is this man to say what the book is about? That's something for the jury. I go, Judge, we're going to have the jury all read Lolita, 400 pages, before you can decide this case. He shouldn't be allowed to say this. And I says, Judge, look, the book may be a metaphor for the crucifixion, for all I know. It may be an allegory about politics in England in medieval times. But on one level, it's about a 50-something-year-old man who wants to have sex with a 12-year-old girl, and he gave it to his daughter on her 13th birthday. I think the jury ought to know that. Especially since, remember, this guy molested them and fondled them when he was purportedly drying them off with a towel. And that's an ambiguous molest. As much as we're quick to say that's disgusting, what kind of thing helps an 8, 9-year-old girl dry off, it's not that obvious once you get in the courtroom that he's molesting them. Maybe he just exercised poor judgment. Maybe he was just trying to help them. Maybe they misperceived. Maybe it wasn't intentional. We got to prove it was intentional beyond a reasonable doubt. Well, this book helps to sexualize this man's relationship with the older daughter. Now we know, I would argue to the jury, that he saw her as a sexual being. Thus, when he was toweling her dry, naked body after trips to the beach, this wasn't an accident. This was somebody that he objectified sexually. And despite my self-perceived, clever, and persuasive arguments, I always thought I won that. I went and looked at the news articles a few years ago. The judge wouldn't let it in. He said, no way, you're not getting it in. I wasn't allowed to put that evidence in. But had I been allowed to put that evidence in, the William Patterson guy, he wouldn't have given an opinion. He would have just given the jury information that helps them decide an issue in the case. And the issue in the case was Griffin Littell's motives. Whether his touchings of his daughters were innocent and excused, or whether they were sinister and sexually motivated. And I needed this expert to explain something to the jury about a piece of evidence that was beyond the average person's understanding. He wouldn't give an opinion about anything. He'd just tell you what the book's about. In the world of child maltreatment, the number one way that we use experts like that is in the child sexual abuse accommodation syndrome. We put experts on the witness stand, not to give an opinion about whether this kid was molested, not to give an opinion about whether this man molested the kid, simply to educate the jury about how kids who are victims of family abuse, family sexual abuse, typically respond. It happens in secrecy. It happens to them in a relationship where they're helpless. They have nowhere to go, no one to turn to, so they accommodate. They wind up figuring ways to cope with the abuse because they're trapped. Once they're trapped, they figure out all kinds of strategies to avoid the guy and tolerate and deal with the abuse. And when they do tell, it's often months or years later. And it's conflicted. It comes out in dribs and drabs. It comes out in a piecemeal fashion. And some of these kids, when they do tell, they take it back. The average juror doesn't know that, man. They don't understand that. That's behavioral science. They don't understand that kids don't tell right away. They don't appreciate that if they do tell, they tell in little bits and pieces. And they certainly don't appreciate that once they do tell, up to a quarter of them take it back. And despite all that, it could be true. See, all of those things make it look like the kid's lying. And the jury will misuse that. Oh, they didn't tell right away? They must be lying. No, there's another way to look at this. Well, when they did tell, they didn't tell the whole story. They left out important parts. They must be lying. Oh, they told it, now they took it back, and now you're saying it happened, and they say it didn't happen? It must not have happened. Why should we believe it ever happened? They said it didn't happen. Well, they could say it didn't happen, and it could still be true. The average person doesn't know that. So we bring in an expert to explain that. We're very successful, by the way, with recantation cases. The good news is because we record them on video. So when they come in and say it didn't happen, we're able to show the video most times, as long as it fits the hearsay exception, 803C27, and it's trustworthy based upon the time, context, and circumstances. So we can get that video in, and the kid comes in and says, I made it all up. I told you, as an example, last week and the week before, about the little girl who was in the car. The guy's name was Stanford Wittenberg. Stanford had her in the car up at Eastside Park. The cops pulled up. It was after hours. They thought it was a couple of lovers, teenagers perhaps, necking in the park after hours. The guy looks up. He takes off. They go through Bunker Hill section of Patterson. They crash into buildings and fences. And the little girl's sobbing and crying. And the lady police officer questions her. She makes some statements. And those statements are excited utterances, I suggested to you. That little girl, and she also said, I can tell you my mom is going to whoop me if I tell you. That was another lesson of that case. She said, my mom is going to whoop me. Those kinds of statements that they think they're going to get punished make it more likely to be true. That is a fact that we look at when we evaluate trustworthiness. Well, that little girl, to add to all the dynamics, she came to court and said it never happened. She recanted. But we were able to convict him. We're very successful with these cases because we use expert witnesses to explain why kids take it back. And we prosecute cases in Passaic County that we feel or we're comfortable with and that we have a chance of successfully convicting the guy. If we don't think we have a chance, then we don't prosecute. And when the kid recants, it's one less witness for the defense to cross-examine. He didn't say anything to her. Thank you, you've been a wealthy witness. You said it didn't happen. This is great news for the defendant. In some ways, our most difficult part of a criminal prosecution is the girl or boy on the witness stand who gets cross-examined. In a recantation case, there ain't no cross-examination. The video gets played, and you can't cross-examine a videotape. So anyway, I believe there's some nice examples of all of this. Yes. Let's take a look at this one today, and then next week we'll look at the others.
What kind of doctor are you?
I'm a pediatrician with specialized training in the field of child abuse and neglect.
Are you board certified pediatrician?
Yes, I am.
Please tell us about your education.
I received my medical doctorate from Boston University School of Medicine. I did my residency in pediatrics at Albert Einstein College of Medicine, Montefiore Medical Center. I did specialized fellowship training at Cornell University, New York Hospital, in child abuse and neglect.
And where are you currently employed?
I'm employed at Hackensack University Medical Center, where I run the program of the Northern Regional Diagnostic Center for Abuse and Neglect.
Yes. We can stipulate the doctor as an expert in medical forensic examination of children with consensually injured, also as a pediatrician.
But it is necessary for you to read your doctor's qualifications regarding this area.
No, I'll permit the doctor to testify with the qualifications.
Thank you. Doctor, do you teach it?
Yes, I am a assistant professor at the University of Medicine and Dentistry in New Jersey.
And what do you teach there?
I teach medical residents, other physicians, day-grade rounds, attending rounds in the field of abuse and neglect.
And prior to your employment at Boykin Pepper, where were you employed?
I was the medical director of a program called the Pediatric Ecology Program. This was a program in Chicago, Illinois. Also a program that was inpatient and outpatient for cases of child physical and sexual abuse.
What do you mean by head-to-toe examination?
Starting as any other medical evaluation or examination would entail, head-to-toe look. Ears, the eyes, the nose, the mouth, the lungs, the heart, the belly, the genitalia, the buttocks, the knees, the toes, from head to toe.
Let's go back a little bit, and I'd like you to tell us about the general examination.
Yes.
Tell us how this began.
The general examination involves the use of a machine we call a colposcope. This is an instrument that allows me to see closely into the genitalia without having to actually go into the genitalia. It is a device that does not touch Destiny, but shine the light on her private parts. Through the image, the image of the private parts are projected onto a TV screen or a computer monitor so that Destiny could see what she looks like as well as see what I'm doing in an effort to decrease anxiety.
Okay. How did this specific area, utilizing colposcope, how did this specific area begin? What was the first area you used?
The first area that I examined is the external genitalia.
Do you have a name for that area?
We call it the labia majora and minora, or the lips of the vagina.
Okay. And what were your findings as to this area?
There were no indications of trauma to this area.
What was the next area that was examined?
The next area involves separation of the labia and looking into what we call the volar space at the hymen and the genital or the vaginal wall tissues.
What was your findings in this area?
This area was normal, no indication of trauma. My conclusion was that the examination results did neither confirm nor deny the possibility of sexual abuse.
Tell us why you arrived at this conclusion.
This conclusion was actually based on two major factors. One has to deal with the architecture of female genitalia, and the other has to do with the healing of injury, both within the time frame as well as the types of injuries one would expect in a scenario like that.
Tell us about the first aspect, the architecture of the vagina.
The architecture of the genitalia, because the vagina is part of the genitalia, is actually, if one were to consider an analogy, is very much like a house. I know that when I was growing up, my mother told me that your hymen was a closed piece of tissue that would break open and bleed when you had sexual intercourse or any degree of penetration. And that she could take me to the doctor, and basically the doctor could tell her that I engaged in sexual activity.
Is this an accurate assessment?
No, in fact, it's quite the opposite. Literature, research, medicine has said quite the opposite in terms of female genitalia. And again, the architecture is very much like a house. If you can envision yourself walking up to the front doors of a house, and let's say that house door has two doors, so you can open the two doors of that house. You walk into a foyer, or what you could call an antechamber, or a foyer. Beyond the foyer, you may see a living room. And between the foyer and the living room, there's an open doorway, let's say with a wood frame around the doorway. That, believe it or not, is very much like the architecture of female genitalia.
where the lips of the vagina are the doors of the house, where the foyer of the house is what we call the vulvar space, or the vulvar tissues. The hymen in this analogy is the wood frame that's around the doorway. The hymen is actually it's an open piece of tissue. It's supposed to be opened. The living room is what we call the vagina. That architecture really speaks to a number of spaces, if you will, within the genitalia, where penetration can happen into the foyer of the house, not the living room, and result in no injury to that hymen. So the emphasis on what the hymen looks like is really one that's erroneous. And the emphasis shouldn't be placed there because penetration into the genitalia can happen without injury to those tissues.
How so?
Penetration can happen directly, sort of perpendicular right into the genitalia, or can happen in a way that is into the vulvar space, similar to the way a hot dog would sit in a bun. You would envision a penis, a finger, an object being placed in the labia, between the labia, into the vulvar space, into the foyer of the house. That type of mechanism, or I should say orientation of penetration, is one that's not expected to result in injury.
The second aspect that you described was pertaining to healing. Tell us about that.
These types of injuries don't heal with a scar. In fact, I like to communicate the analogy of getting an injury inside your mouth, which is, from a tissue perspective, very similar to the tissue that's in your genitalia, female genitalia. If you were to, let's say, bite the inside of your mouth, you could get a cut or bruise to that area. Generally, those injuries heal quickly. And if you were looking in your mouth into the mirror, you probably would not find a scar. It's very similar to the injuries that we see in the genitalia. Bruises, abrasions are going to heal very quickly and do not result in scar formation. Other types of injuries, like deep lacerations, heal via different mechanisms. The body heals deep lacerations differently because they involve many layers of tissue, many layers of cells. Those types of injuries heal via a scar and would result in a deformity of the genitalia, of the tissues, that I could see years later.
So you see there, Dr. DeBellis testified as an expert witness, and for the most part, she testified about the witness in that case, Destiny. That was the victim in the case. She examined Destiny, and she gave an opinion about whether Destiny's genitalia was injured in any way or changed in any way because this case involved allegations of penetration and sexual assault. The end of her testimony, she provided information to the jury about the basis for her opinions. And very often, in fact, the vast majority of cases involve no trauma or injury, despite the fact there's an allegation of penetration. And in most cases, expert witnesses like Dr. DeBellis take the stand to explain not why there's injury, but to explain why there is no injury. So you saw the bulk of her testimony was about the fact that this child alleged sexual penetration and there were no findings. Her anatomy looked normal. And Dr. DeBellis gave information for the jury about a highly relevant part of the case so that they can draw their own conclusions. And the information she gave was an explanation of why there are typically no findings in penetration cases and what it is about the anatomy, female anatomy, that causes there to be penetration without any trauma or findings. And we learned that a couple of things going on here that she doesn't always say directly, but the orientation of the male penis in these cases is not full penile penetration. It's often, as she describes, like a hot dog in a bun. And that is the penis rubs up against the labia minora, majora, the vaginal lips, and arousal and orgasm is achieved that way. That would be a penetrating act. It would intrude into what she calls the vulval space, the space in the vulva between the vaginal lips and the vagina itself. As she says, there's a series of spaces there. So that's penetration. But that's not going to leave any injury. And even if there is full penetration or digital penetration, the tissue that makes up female's anatomy and female children's anatomy heals very quickly. And she gives you the analogy of an injury into the interior of the mouth. When you bite your cheek, it heals quickly within a day or two. It's like it never happened. And that's important too. So in most of these cases, the doctor takes the stand to educate the jury about children and female anatomy, rather than give an opinion about this case. Very often I have a case where the child is evaluated by a doctor in South Jersey, let's say, or in Sussex County, or for whatever reason, some other pediatrician, and I bring in Dr. DeBellis or Dr. Sands from St. Joseph's Hospital in Patterson, and they don't have anything to do with the kid. But I put them on the stand, much like the professor from William Patterson was about to testify, to educate the jury about something that's counterintuitive. Because, remember, she started out by saying when she was growing up, her mother made it clear to her that if she was fooling around with boys, she could find out. She could take her to the doctor, and the doctor could look at her vagina and tell whether she was having sexual contact with boys. That's what the upshot of that was. When I was growing up, my mom communicated to me or told me that the hymen was this sheath of tissue that covers the vagina, and any intrusion would leave marks, and the doctor could see it. Well, that's not the case at all. We know from the testimony, and now the jury knows from the testimony, that, first of all, the vagina is within the human body. It's not on the surface. It's within these spaces. You have the labia, the majora, the minora, you go in the vulvar space. And then there's the vagina, and what she calls the wood frame is the hymenal tissue, which is open. Things could go in and go out. Biology makes it so things could go in and go out. So a finger could go in there, an object could go in there. It could cause minimal damage or no damage. But guess what? The jury doesn't know that. The fact finder doesn't know that. So these doctors come in and they educate the jury. The jury, in fact, thinks the opposite. Just like with the psychological testimony. Just like with the testimony about child sexual abuse accommodation syndrome, the jury says, well, if something happened to the kid, she probably would have told right away. No. It's the opposite of what you think. That's what a lot of people think, but it's wrong. Kids don't tell right away. Same thing here. Most people, to this day, I would argue, still think that if there is sexual contact with the vagina of a female adult or child, that there will be residual. There will be evidence. There will be trauma. And that's not the case. And that's why the jury needs to be educated. Otherwise, they come out with a false conclusion. A conclusion that's based upon their perception, okay, the myth of what they think about female anatomy, rather than the fact. And the fact is quite different. There are people who were impregnated that had normal hymenal tissue. Okay? That's the research that she's talking about. There's lots of research in this area now. But there is, among the most compelling research, pregnant women who have normal findings and intact hymenal tissue. Okay? We know they had sex, right? But the jury doesn't understand that. To this day, as we stand here, somewhere in this country, some mama's taking her daughter to the doctor to find out whether they were abused or not. And that's what the jury thinks happens when they go back in that jury room. So we educate them. That's one form of expert testimony, is to give them, that doesn't mean we win, that doesn't mean the kid was molested, that doesn't mean this guy's guilty. All that means is the jury's got enough information so they can make an informed decision about what happened. Not one that is born of the Dark Ages or the myth of female anatomy or the myth of how kids react to being molested by their uncles and their dads and their family members. Okay? That's the worst case scenario for DAGs and prosecutors, is that they decide a case based upon what they think happens rather than what actually happens. So we use expert witnesses to educate the jury. And that is an effective way to level the playing field and advocate for kids within the family courts and the criminal courts. Any questions about that so far? You know what a lay witness is now? That's an eyewitness. That's somebody who was there at the time and saw the guy pull the gun out or heard the shots or was involved in the case. And an expert witness comes in and either gives an opinion about something they were specifically hired to look at in the case, maybe evaluate the fracture of the kid's leg, maybe break down the computer and look at the hard drive and give an opinion about whether the child pornography was possessed for more than an instant or not. Or they come in and not know anything about the case, and they educate the jury about how kids react to abuse, or how the female anatomy works, or how email works, and how files are downloaded, without even talking about the case. Or they come in and say, hey, this is what the book Lolita is about. They educate the jury, because that information is part of the information that's important to resolving the case or deciding the case. What is something that is, when we say something's different from what people expect, we call that counterintuitive. It is the opposite of what intuition tells us. You know, intuition tells us kids tell right away. Intuition tells us kids tell it all at the first telling. Intuition tells us that if the doctor looks and checks, they can tell whether someone had sex. Some things are counterintuition or counterintuitive. Unfortunately, lots of them in child maltreatment. So much of what we do is the opposite of what people think. The complete opposite. In the area of domestic violence and spousal abuse, what is something that jurors and average people just can't understand that a prosecutor or a DAG might need to bring an expert witness in? Right. What did he say? Why she stayed with the guy. Why she remained with the perpetrator. Right? There are a number of nuanced elements to battered spouse syndrome. But one of the most important ones, one of the issues that jurors have a tough time wrapping their arms around, that average people have a tough time understanding, is why, after getting her ass kicked once, would she stay with him? And worse yet, in the minds of the average person, why would she go back? And there are a number of complex psychological and social and economic and familial dynamics that explain that behavior that the jury ought to know about if they're going to make a decision. And in those cases, you may bring in an expert from the local women's center, or even a seasoned DIFUS worker with 4 or 5 years under his belt or her belt, to testify about how battered spouses typically react to their abuse and why they make the decisions they do, in a general way. So that's very similar to the child sexual abuse accommodation syndrome, in that the behavior of the victim is counterintuitive. That the behavior of the victim is the opposite of what intuition tells us. or what we expect. Our intuition tells us somebody hurts us and injures us and beats us up. We don't go back home and hang out with them. We don't sleep with them the next night. We get the hell out of there. But that's not the way it works in this class of cases. And the jury ought to know that. Doesn't mean he's guilty. Doesn't mean the victim's telling the truth. It just means that the jury gets sufficient information to make an informed decision. And the way we do that is by using expert witnesses. And we'll talk more about that next week when we wrap up this learning module. Okay? Any questions at parties? Okay, got another week to finish this one up.